A very good evening to you, ladies and gentlemen. I am happy to welcome you to the 25th webinar of Series 6 on Basics of Law titled Land Development Ordinance. This is the 65th BSR webinar for the years 2025-2026. This webinar series is organized by the Webinars and Legal Symposiums Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the Chairman of the Webinars and Legal Symposiums Committee and the President of BSR, Mr. Rajiv Amarasuriya, the Co-Chairman, Mr. Chaturaya Galhena, Secretary of BSR, and Mr. Pasandu Silva, Treasurer of BSR, and the conveners, co-conveners, and the members of the Webinars and Legal Symposiums Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of BSR for all the support and guidance. For today's webinar of Land Development Ordinance, we have with us an esteemed panelist, Ms. Sudarshini Kure. Ms. Kure, having obtained her Bachelor of Science in Management degree from University of Sabaragamuwa, she completed Bachelor of Laws degree from Open University of Sri Lanka and was enrolled as an attorney at law in December 2006. Ms. Kure also holds a Master of Laws degree from the University of Colombo, and she has been in active practice for the past 19 years, focusing mainly on civil appeal matters in the Court of Appeal and Supreme Court. I warmly welcome Ms. Sudarshini Kure, attorney at law, for today's session. To moderate today's session, we have with us Ms. Migara Das. Mr. Das is an attorney at law of the Supreme Court of Sri Lanka. He is also a holder of Bachelor of Arts Special Degree in Sociology from the University of Colombo and a Master of Laws from the University of Colombo. Mr. Das has more than 10 years of practice in the private bar as a lawyer specializing in civil law and public law, handling areas such as family law, labor law, land law, money recovery law in civil legal practice, and handling cases in administrative and fundamental rights law in public law practice. I also warmly welcome Mr. Migara Das for today's session. And without any further ado, I invite him to commence today's proceedings. Over to you, sir.
Good evening, ladies and gentlemen. So I warmly welcome you all for this very timely webinar on the subject of the Land Development Ordinance. And I also am privileged to moderate this session with Mrs. Sudarshini Kure, where she can enlighten us on the developments and changes in this particular all-important aspect of law concerning state lands. So to begin this webinar, I would like to bring in the background of the Land Development Ordinance coming into Sri Lanka. We, as Sri Lankans, throughout history had been an agrarian society built on peasantry. And during the colonial period only, the issue of landlessness came with the colonial rule, especially with the introduction of the Crown Lands Encroachment Ordinance and the Wastelands Ordinance in the 1800s. Thereafter, since the landlessness was a troubling concern amongst the masses, the colonial administration brought forward a land commission in 1927. So the basic premise of the land commission was that the crown is the custodian of the land and that the land should be used for agrarian and cultivational purposes. And for that purpose in mind, the Land Development Ordinance comes into being. So I would like to begin this discussion by posing the question, or rather opening the floor to Mrs. Kure to explain to us the present relevance of the Land Development Ordinance. Since 1931 up to now, it has almost survived a century in Sri Lanka. So the relevance of the Land Development Ordinance as a law in Sri Lanka, Madam, you can commence this webinar by explaining to us how relevant is the Land Development Ordinance in today's context.
Thank you, Migara. Thank you, Visuri. Good evening to everyone. I would like to start this session by saying that our country is mainly on agricultural things, and land is very important to our country. So when it comes to land, in order to resolve disputes between siblings and relations, the Land Development Ordinance plays a very important role in our system of law. One of the main important sections, I will straight away come to the act. In this act, we have the alienation of state lands, that is section 19 onwards. The earlier sections, of course, they are with respect to mapping out and things which are not essentially important for the land development ordinance case studies. But section 19 is a very important section where the alienation of state land specifically mentions as to how land is alienated, state land, on permits and on grants. Sorry. Then, and the selection of persons is covered from section 20 onwards. Under section 19 of this act, it is very important to consider section 6, subsection 6, 19 subsection 6, where it is stated, every grant issued under subsection 4 shall contain the conditions that the owner of the holding shall not dispose of a divided portion or an undivided share of the holding, which is less than the extent of the subdivision or the minimum fraction specified in the grant. And in B, it says, dispose of such holding except with the prior approval of the government agent. That is, you can't dispose a fraction, a minimum fraction, less than the minimum fraction. And also, you can dispose except with the prior approval of the divisional secretary. So when you dispose with the prior approval of the divisional secretary, it comes to the register like a normal transfer. It goes like a normal transfer. So that we have to keep in mind. So then the ties to the land development ordinance, that state land, although the conditions carry with it, conditions are carried along with the land, but it goes like a normal transfer when you get the the approval of the divisional secretary to transfer that land. Then I would like to take you all to the dispositions. Power of owner to dispose the holding. Now you can mortgage subject to certain conditions. That is also there from section 42. That is, you can mortgage to state banks, and but you cannot mortgage it to certain other banks which prohibit. Now, so for instance, State Mortgage Investment Bank, Development Finance Corporation of Ceylon, National Development Bank, you can mortgage this particular state land if you have got it under a permit or under a grant. Then section 46 specifically states disposition of land alienated on a permit. Then section 48. From section 48 gives the succession. That is a very area, that's a very important area where a lot of litigation commences from this. I'm sure Migara will know that from 48, 48A, 48B, that is when the grantor dies, the spouse will be the life interest holder. But the life interest holder, according to 48B, he or she cannot nominate. No power is given to nominate a successor. And no power is given under the Act to dispose of such holding. So those are restricted because sometimes in these village areas, people have so many grudges and things, and then they try to dispose to one sibling, and then a dispute, a case, an action will start, and there are a lot of problems with regard to that. So once a grantor decides as to whom it should go to, the succession, that is set law. The spouse cannot decide as to who should get it next. If the grantor has not nominated, then the sections are section 72 and 73. Now, in this context, it is very important that under section 73 gives a specific date of succession. The specific date of succession is when the grantor dies, the spouse becomes the life interest holder. And the eldest child, supposing the eldest child is surviving, he or she, under the new act, he or she will get title to that land as the next successor is only on the date of the death of the life interest holder. That is what the section says. In this regard, there is also a case law which His Lordship Justice Arjuna Obesekara has given in the Court of Appeal. That is somewhere decided in 2018. This is CA writ application. I don't think this is reported. CA writ application 112/2013, where it was decided that the exact date on which a succession, where the grantor has not nominated a successor, is the date on which the life interest holder dies, and on that day only, the according to the third schedule, the first child gets title to that land. Then coming back to the Act, the important sections with respect to this, a lot of disputes arise in courts, is also where the nominations are being changed. That is section 52, 58, and 60. So under these sections, the Act prohibits just to nominate. You can't change the nomination. You have to register the cancellation, and then you have to register the new nomination. That is the law. Sometimes these divisional secretaries also try to do various tricks, and then they try to, without registering the cancellation, they try to register the new nomination, which is incorrect. So in order to prevent that, the legislature has brought in these sections, these important sections, that is 52, 58, and 60. And also there's another important thing in these sections with respect to the nominations and cancellations. That is, you have to register these nominations and cancellations before the death of the holder. that is there. So I'm just reading from the Act. Documents of nomination or cancellation invalid unless registered. So you have to register them in the correct folio. And also section 60 says, nomination or cancellation of nomination invalid unless registered before the death of the owner or the permit holder. Now, with respect to the nomination of a permit, a very important case I would like to share with you is PSN versus Vijay Singh and others. That is 2002, 2 SLR 242. PSN versus Vijay Singh and others, 2002, 2 SLR 242, where it is said that if the permit holder, original permit holder, nominates someone in the, according to the schedule, third schedule, then that the nominated successor will follow to even into a grant's succession. That is, if the permit holder gets a grant later on, the nomination in the permit will follow. So that is what because that is not covered from the Act, but it is covered from this law. It is a very important case law, PSN versus Vijay Singh, 2002, 2 SLR 242. Then also the failure of succession, that is under section 68. That is, if you don't come into possession of the land or holding within a period of 6 months from the date of the death of the permit holder or the grantor, then it is considered as a failure of succession. Section 68 is also important in this Act. Then the cancellation of grants and permits. That is mainly under 104, section 104, 106, 109. Now the cancellation of a permit is allowed even for a divisional secretary. He can cancel the permit on the basis that certain conditions are not fulfilled, and it need not be referred to the president of the country. But in a grant, it is only the president who can cancel a grant. Now, with respect to that, the old Act, before the amendment, even in that also, commissioner has to refer these matters to the president, and it is only the president who can cancel such a grant. I will come to the new amendment after I discuss the important sections. And then there is also the interpretation section. Mainly it is, these are the most important sections under which now under 104 and 106, the divisional secretary has to send a notice and then call for an inquiry, and then ask for show cause as to why the permit should not be cancelled. So those are the important sections under the Land Development Ordinance, which which is mostly scrutinized in the courts with respect to lots of disputes that are happening in the country.
Madam, now, since you discussed some of these sections,
Yes,
to bring in a point that I think is worth highlighting, the
yeah,
Land Development Ordinance in 1935 was
yes,
introduced for that particular period. Now,
yeah,
almost 100 years later, almost not 100 years yet, but almost 100 years later, we are facing a situation where this law needs to be developed and amended according to the needs of the time. Now,
that's right. Yes,
since you addressed the issue of succession, madam,
yes,
now section 72 and the third
yes,
schedule thereof, how has this particular criteria of giving succession rights to the eldest male child, how has
yeah,
it changed over time in terms of
yeah,
the new amendments introduced to the law?
yes, yes, Vigara. Vigara, now according to the old law, they only gave preference to male children, first male children who are born. But later, even females can also do agriculture. So on that basis, the new act has that is Act number 11 of 22 has introduced a new schedule. The third schedule, that is in this Land Development Amendment Act number 11 of 22, section 10. The third schedule to the principal enactment is hereby repealed, and the following schedule is submitted. The group of relatives from which a successor may be nominated for the purposes of section 51 shall be as set out in the subjoined table, in which children include female or male children. So that is a very important amendment, because otherwise still how much the act tries to amend and repeal and bring in new acts, Vigara, I think still the disputes will arise in many aspects, which will have to be dealt with accordingly with the time. So that is how this amendment has come into operation, because there were so many requests to take off this gender biased thing out of this act, because even females do agriculture in those remote areas. That is how and also in the amendment, children includes a child adopted according to law. That is also has come into picture, because now normally all these in the table, it has to be a blood relative to nominate a successor. But this has changed, because even adopted children have been accepted into this third schedule, and but they have kept the relatives they should be blood relatives. They should be connected to the grantor by blood, so that they have kept it.
One more question, madam. Now, you're correct about how the
Yeah.
gender bias was erased by an amendment subsequently. But
Yeah.
there's also another problem that would arise over time. Now, there
Yeah.
can be a hierarchy of blood relatives, regardless of their gender, to succeed in terms of the amendment. But there are
Yes.
also instances where one of the siblings can be in possession for a longer time, but may
Yes.
not be in the hierarchy. How has
That's right.
this issue been addressed in terms of the amendment of the Land Development Ordinance, madam?
In this, can you
Yeah,
tell me
what I'm
that
saying is,
again?
what I'm saying is now, despite there being a hierarchy from the eldest to the youngest, there
Yeah.
may be instances where one particular sibling, despite not being the eldest, would have been in possession for a longer time. And that person, under the old law, would have been neglected in terms of the hierarchy,
That's right.
despite being in possession. How has
Now,
this been addressed, madam?
that has not been addressed actually. Now, you mean the possession? The possession, yes. The possession. Old law, earlier law, they did not address that. So even if one sibling is in possession and the first child gets the chance to get the grant or the permit. But now that has been corrected by the amendment that is in the proviso. In the third schedule, 1D, notwithstanding the provisions of paragraph B and C, where any person in the order of priority in which they are respectively mentioned in the subjoined table developed such land, the title to the holding or the land shall not devolve on the older person referred to in paragraph B, but on the person who developed such land. So that is there. That is how they have dealt with it in the amendment.
And also, madam, now there are instances where the particular permit or a grant is given, certain parties obtain their rights to the holding based on misrepresentation of facts.
That is
as
right.
To who developed and whether they were in possession or not. So this issue of misrepresenting facts in obtaining rights to holdings, has this been addressed over time in land development law?
That is right. In the old law, that was not there. Now, in the new amendment, if you can prove to the Commissioner General of Lands or to the Divisional Secretary, he will refer it to the Commissioner General of Lands, saying that the person who has deliberately given false information in obtaining the grant or the permit, then that can be cancelled. But even then, a permit can be cancelled by the divisional secretary. But the grant, the commissioner of lands will have to refer it to the president for cancellation. So that is how, that is section 104A has been introduced by the new Act number 11 of 2022. That is how I can read that section 104A. If it appears to the Commissioner General of Lands on the information as may be available or received from a person having an interest to the title of the holding under the provisions of this Act, as the case may be, that the owner of a holding has deliberately given false information in order to obtain a grant, or grant has been issued to a person other than the legitimate occupant, the Commissioner General of Land shall issue a notice to the owner or occupier of a holding in the prescribed form. So that also has been covered by the new amendment. That is section 8 of the Act number 11 of 22. So that is the that is where we stand today, Migara.
Now also, madam, another interesting area that you raised was regarding life interest rights of a spouse, of a surviving spouse. Now, madam, practically speaking, in a situation where either a permit holder or a grantee dies, while nominating a successor,
Yeah.
While one of the children is nominated as a successor, the
Yeah.
owner of the holding or the permit holder dies.
Yeah.
While leaving behind a spouse.
Yeah.
Then how does succession come into play, madam? Does the successor, the nominated successor, come in the line of succession, or does the spouse get
The spouse,
priority in succession?
yeah, the spouse has the life interest. So before the according to section 73, that is 73 specifically says the date on which the I can read it, date of succession, section 73, title to a land alienated on a permit or a holding shall be deemed to have devolved on any person entitled to succeed to the land or holding under the provisions of section 72 as from the date of the death of the permit holder or owner of the holding, if such permit holder or owner died without leaving behind his or her spouse, or if such permit holder or owner died leaving behind his or her spouse, upon the failure of such spouse to succeed, or from the date of the death of the spouse, as the case may be. So, if there is no spouse, the nominated successor will automatically get the succession on the date of the death of the grantor or the permit holder. If there is a spouse, then that spouse fails to succeed within 6 months, then it's considered as a failure to succeed. So she will lose the life interest. Then also, the nominated successor will get the title, get the succession from the date of the death of the grantor or the permit holder. Now, the interesting point is when the spouse comes into possession and takes up the occupies the subject matter, then the nominated successor cannot succeed until the death of the spouse, that is the mother or the father. You will have to wait until they are also dead and gone. So, in order to actually, if you look at the act tries to covers the minimalistic matters that can arise and can go into dispute. So they have tried to cover as much as possible. So this is one area where in these villages, that is how things happen. So that also they have covered and very clearly given under section 73. When there is a spouse, if she comes into possession, the nominated successor will have to wait. That is the position vigara. So on those lines, that is how succession will come into operation.
Another point that you made, madam, at the very beginning was regarding the award of permits, and permits subsequently being awarded in the form of grants. Now, in terms of the land development ordinance, there is the procedure called the land kachcheri, where only upon a land kachcheri that holdings are disposed to persons. Can you explain to the audience of this particular procedure of a land kachcheri and how that works in practice?
The land kachcheri, that is coming under section 20. Section 20 and 23. Selection of persons to whom state land shall be alienated, that is by at a land kachcheri, that is like an inquiry. As to now, the divisional secretary will call upon the members of the family, the siblings, and he will inquire into who is in possession of the land, who is developing the land, and he will try to give to the best person suitable to receive the permit or the grant. Now, supposing there is a person, there's a sibling who has a house in the highland, and there is another sibling who is developing the other area of the highland. So there is a dispute. Now, one is in occupation, one is developing the land. So in that context, the divisional secretary will try to provide either a permit or a grant to the person who is in fact developing. And if the grant or the permit, or if there is no permit, if there is no grant, then he will have to refer the matter to the land commissioner with respect to the disposing or alienating or breaking into two parts. And then the divisional secretary will deal with it as to who should get that is a land kachcheri, where the land commissioner is satisfied that immediate alienation of any land under this ordinance is desirable in the interest of an applicant. For that also, Megara, I think the people who are in occupation must make an application to the divisional secretary, and then only the the divisional secretary will call upon these people for an inquiry at the divisional secretariat to find the most suitable person to be given the grant or the permit. So that is in section 20. Section 22 also deals with applications for land, when and how received and considered. The government agent may, in a notification under section 21, fix a date before which application shall be made to him for the land proposed to be alienated at the land kachcheri, appointed to be held by such notification. So actually he has to notify all the parties and then decide. Then section 23 discusses powers of government agent at land kachcheri. That is, at a land kachcheri, the government agent may, having considered the applications referred to in section 22, select the applicants to whom state land shall be alienated either immediately or on or before a future date. With the provisions of this, he can even reject any application where the provisions of this ordinance relates to such application have not been complied with. So that is how Megara, the land kachcheri works, and the alienation of state land will take place under the land development ordinance.
I would also like to remind our audience that their questions and queries can be posted in the Q&A box. And at
Yes,
the end of
that's
this
right.
webinar, we can address those concerns. So moving on, madam, now the usual understanding amongst the public and most lawyers is that
Yeah.
any grievance suffered by a person under the land development ordinance, who is
Yeah.
either owner of a holding or a permit holder, the
Yeah.
remedy is a writ in a court of appeal.
Yes.
But there are also instances where the jurisdiction of the district court can be invoked with
Yes.
regard to a owner of a holding. Can
That
you
is right.
elaborate on this context, madam?
On this, yes. Now, there's a very important case. I don't have the reference, but Ranasinghe versus State Mortgage Bank. Now, in that, it has been decided that even a district court can give a declaratory order, judgment, to say that if a grant or a permit has been wrongly issued to a person, that procedure is wrong, or it should not have been given to a certain person. But there is a misconception among the people and the lawyers and the judiciary, and that these types of declaratory matters cannot be decided by the district court, but it should only be writs. But that is not so. Even if you file a district court action and if you ask for a declaratory relief, that can be given by the district court by calling evidence, maybe from the divisional secretary, from the land officers, maybe the commissioner general of lands, and how they granted the permit or the grant, whether it is according to procedure, whether there are other siblings, and how they gave the grant or the permit against over the other siblings. All that can be gone into by the district judge and decided and given a declaratory decision. It's not only the writ remedy people have, it's also the district court. The district court may not be able to quash a permit or a grant, but a declaratory judgment order can be given on the procedure followed in giving the permit or the grant. The writ remedy is mainly used to quash the permit or the grant given, because that is either erroneously given or the parties have misrepresented facts to the divisional secretary, or the divisional secretary has taken a wrong decision or done something wrong. So on those matters, the writ will lie to quash those permits and grants and to give it to the correct person. But the district court may not be able to do it, but the procedure can be looked into. The procedure can be looked into and can be given a decision to say what is invalid cannot be invalidly given to, supposing the divisional secretary on fraudulent information given by a party directs a person to be given a grant, then that is invalid. The decision of the divisional secretary is invalid. So that the district judge can make a declaratory judgment or order on that. So those are the matters that is there with respect to district courts and writ court.
To going further on the district court jurisdiction, madam, now like any occupier of land, people who hold occupation under a grant or a permit may also face the threat of encroachments or their possession being disturbed. Now, with regard to a ordinary private title, a person has a right to institute action as a vindicatio case.
Yes.
Now, this might be slightly different in the context of a permit holder or a grantee. How can a grantee, affirm their rights when they are disturbed by an encroachment or their possession is disturbed by other means by a third party? Does the district court still provide remedies for grantees and permit holders under the Land Development Ordinance?
Yes. In fact, that is actually very much similar to a normal vindicatio action. That is what Palisena versus Pereira, 56 NLR 407. 56 NLR 407, Justice Gresham J. has held. That is, even a person who has a permit can file a vindicatory action, vindicatio action, to eject a trespasser from the possession, from who has encroached onto the subject matter. And also Bandaranayaka versus Karunavati. It's a recent judgment. 2003, 3 SLR 295. In that also, it was held that permit holder under the Land Development Ordinance enjoys sufficient title to enable him to maintain vindicatory action against a trespasser. That is Bandaranayaka versus Karunavati, 2003, 3 SLR 295. So, and also there are so many other cases which has been decided that a permit holder or a holder of a grant, they are very much similar to having a normal title, just like a normal person who has a any deed, private deed. It's not a private deed, the permits and grants, but the action to eject a trespasser is very much similar. It can be a reivindicative action because the prayer will be, it will be a declaration of title. So if a permit holder has a declaration that he is the lawful permit holder, he can then ask for the ejectment of the trespasser. But of course, he will have to prove in the process of the trial that this person is a trespasser. So it will be just like a normal reivindicative action. For that, the district judge must be mindful that the permit or the grant that he claims to have rights in the land is validly obtained, properly obtained, without any fraud. So just like a normal reivindicative action, when you ask for a declaration of title, in that also the district judge has to go through the deeds and the evidence to see whether this person, the plaintiff, has a right or title to the land. So on those matters, I will say it's very much similar, Vigara. Even if you have a permit or a grant, if you want to eject a trespasser, it's very much similar to a normal reivindicative action where you file by these private parties. So that is, and even you can ask for damages, like in a normal case, if he has damaged your property, the permit holder or the grant holder, they have the right to ask even for damages from the trespasser.
Another frequently occurring issue is, madam, now once a permit holder or a grantee dies, then there is a contest amongst the children to succeed. One child may challenge the nomination, saying that it is not valid. One child might say that she or he had been in possession. Now, in such a situation, what is the duty of a divisional secretary as the government agent envisaged under the Land Development Ordinance? And what is the role expected of the divisional secretary in light of such a contest amongst the children for succession?
In that type of situation, the divisional secretary will have to go into all the details of that family. As to now say, sometimes there are 10 children in that family. The grantor might have 10 children. So some may be residing in the premises, some may be abroad, some may be in Colombo. And he has to look into the fact, mainly under the new amendment, as to who will be developing this land. Because that is how the Act wants the divisional secretary to select the person, because the Act is very specific. Act says, even if there are children, older children, that will not prevent people, the siblings who are in possession and who are developing such a land. That is specifically there in Act number 11 of 22, third schedule, 1D. 1D specifically mentioned that even if there are older children that should go, that the grant or the permit should succeed to according to the third schedule, that will not bar another sibling who is in fact developing this land. So the divisional secretary has a duty to look into the facts and matters as to how the siblings who has developed this land, who has developed the land, and that person should get the permit or the grant. So for that, he has to call all the siblings, and they must be allowed to produce the acreage taxes or the fertilizer, whatever they had used. And if they are, I'm sorry?
Fertilizer subsidy.
Fertilizer if they have used, and if they are in the Govi Sangvidhana, also they are sometimes, they are members of this Govi Sangvidhana. So they can bring letters, they can bring evidence to show that they are actually doing the paddy field or whatever the agriculture. So for that, the divisional secretary must be mindful. Sometimes even the divisional secretary personally knows. He can personally go into the land and check and see as to what is happening to this land. So for that, divisional secretary will have to keep an inquiry to find the correct person to give the grant or the permit. So sometimes when the divisional secretary selects a person who is in occupation over a sibling who is actually developing the land, then there will be disputes. So that is a gray area which the Act has not covered yet. So we will, I think the legislature will look into it. Because supposing now someone is living in the house and that person is not developing the land, and another sibling is developing the land or carrying on the work of the paddy field. So there is a dispute there. So, and supposing the grant does not allow the minimum fraction to be divided and the house to be given to the person who is in fact residing, then a dispute will arise. So actually, those are matters which now, because there are, even in the remote areas, people are growing, numbers of people are growing. So in such a scenario, the Act should in fact allow fractions or to be divided among the siblings, maybe the highland and the paddy field accordingly. So that is how it is, Migara.
Now also, madam, on the same subject matter of nominations, there can be multiple nominations on a holding, and the siblings might be challenging one nomination over the other, saying that the particular nomination is fraudulent or forged. Now, I think section 56(1), I think you addressed this, madam. Section 56 provides for a particular form for nominating and cancellation of nominations.
That's right.
And section 58 also sets out certain requirements to complete a nomination. Maybe you can elaborate on that also, madam, so that this contest on multiple nominations and how the law has tried to resolve that ongoing dispute that had already taken so much of time and matters in terms of the Land Development Ordinance.
Yeah. On on the nomination, Migara, 56, 58, 60 is the important sections to be looked into. Now, in for a nomination to be valid, that has to be registered before the death of the owner or the permit holder. That has to be done in the correct folio, or even for a permit holder, you can register it in the ledger. You can register it in the ledger. If you are going to cancel a nomination, that also later, if the permit holder or the owner thinks that the nominated successor is not suitable, in order to cancel that, even for the cancellation, it's the same form. You have to fill it out and again present it for registration at the registry, land registry, and those have to be registered. That also must be done before the death of the owner or the permit holder. Sometimes when these villagers, what they do is, when they have 3 children, they nominate all 3 children. So what happens is, so when it comes to the grant, there is a prohibition on subdivision and the fractioning. Then that nomination becomes invalid under the under section 75, because it's contrary to the provisions of the ordinance. So under section 75, if you go through, nomination or cancellation of nomination is invalid if contrary to provisions of this ordinance. It says any nomination of a successor and any cancellation of any registered nomination of a successor shall be wholly invalid if such nomination or cancellation in any way contravenes the provisions of this ordinance. So then what happens is, the nomination is cancelled, and then it will go back to the 3rd schedule. So according to the 3rd schedule, it should be the first child. So then also there are disputes. So this act, on one hand, tries to resolve disputes, and on the other, lots of disputes are arisen. Can't help. That also can't help, because that is how, because it has to go to one person, because the legislature tries to minimize the fractioning of the lands, because they want to give it to one person so that he will do the agriculture part, maybe a paddy field, or maybe coconut plantation, or maybe any other small plantations. So on that basis, the nomination should be according to the provisions of the ordinance. It should not contravene the conditions set out in the permit or the grant. When it contravenes, supposing you have three or 5 children, you try to put everyone in the nomination. So when it comes to fractioning of the land, there is a problem. So then it reverts back to the first schedule. So then again there will be problems among the siblings. So the divisional secretary has to be mindful as to who it should be given to.
Madam, I think there's one more question from the audience.
Yes.
I think that's also a very pertinent question. In
Yeah.
the case where a permit holder or a grant has a spouse, but it is
Yes.
later discovered after the death of the grantee or permit holder that he had divorced his spouse before his death, then
Yes.
does the life interest set out in section 48 come into play?
No, it does not. It doesn't come, because you have to be the spouse at the time of the death of the grantor or the permit holder in order to get that benefit of a life interest holder. So it does not pass on to the spouse, former spouse who had divorced, because that connection is lost in between. So it doesn't pass on to then the section 48 does not come into operation of a spouse who will get the life interest of a holding or a permit holder. It does not.
Madam, I think one more area that you explained was section 19, subsection 7, regarding mortgaging
Yes.
of state land under the Land Development Ordinance, where
Yes.
there was the requirement of obtaining the approval of the divisional secretary.
Yes.
Now, madam, in terms of, now this is a bit of an open-ended question. Now,
Yes.
certain amendments that come into play have broader policy considerations and also socio-political impacts of their
Yeah.
enforcement. Now,
Yeah.
in terms of the 2022 number 11 amendment,
Yeah.
section 4, madam, section 4
Yeah.
provides for an amendment for section 19, that is
That's right.
regarding mortgaging.
That's
If I may
right.
read that, madam, it says, notwithstanding the provisions of paragraph B of subsection 6, the approval of the divisional secretary shall not be required when mortgaging such holding to a licensed commercial bank, the State Mortgage and Investment Bank, Development Finance Corporation of Ceylon, the National Development Bank of Sri Lanka, National Housing Development Authority, the Housing Development Finance and Corporation Bank of Sri Lanka, any registered society or other prescribed institution. Now, by
Yes.
the looks of it, madam, by the looks of it, this has very far-reaching implications to the very core of the Land Development Ordinance, meaning the fetter that was on a divisional secretary of granting approval or not for a particular mortgage of a Land Development Ordinance land is completely removed. Is completely removed. According to you, what are the far-reaching implications of this most controversial section, madam?
I would say I don't think there is any problem in this, because now supposing it's like you have a right, the state gives you permission to develop the land, to be in possession of the land, and to do whatever you like. That is the understanding in a sort of a on the conditions you have a right to possess and to develop the land. So in those four corners, I think my idea is that under section 4, the person who is having the rights of that land should also be able to mortgage it to only the specific institutions, finance institutions, and get a loan or whatever, because that is up to him. That is up to the person who is in fact in possession or is trying to develop this particular subject matter. So I think I don't think there are any negative, but of course, when this person who is, say, the permit holder or the grantor, if he's unable to pay, the mortgage, then the bank will come and sell it, and then he will lose rights to that. That aspect is also there. So
Which is why I posed the question, madam. Now, the very object of Land Development Ordinance was to preserve the agrarian agriculture or the agrarian economy and the peasantry of this country, and also
yes,
to create a culture of cultivations among state land.
yeah,
Now, when this particular subsection 7 is introduced, Now,
Yeah.
earlier there were specified institutions that you can mortgage, but
Yeah,
when the
that's right.
term any licensed bank and any registered society or other prescribed institution comes into play, that gives a very broad interpretation for mortgaging it. And
Yeah,
also the
yeah,
letter of the divisional secretary is removed. So
yeah.
that was why I asked the question whether this particular section affects the very core of the land development ordinance, that is to preserve the cultivational or the agrarian economy of the country.
Yeah, the thing is this, Vigara, now supposing the person who does not have the means to, of course, sometimes some people, some holders or permit holders, they will, without thinking, they will mortgage it and do various things. But there are actually people who do not have the means to develop the land, may try to get a loan, mortgage the property, and to get a loan, and then they will try to develop the land. There is also the positive side, but also the negative side, like you said, which will directly affect the main purpose of developing the agricultural land. That is also there. But I think that section has been introduced to a person who does not have the means or any strength to develop the land. So actually, uh, when they introduce the divisional secretary shall not be required, approval of the divisional secretary is not required. That's a bit of a dangerous thing. That amendment, people might try to misuse it. And because it's state land, they will just mortgage these lands, and then they will not develop them, like you said. So I think this amendment may have some negative implications on the act, because the approval of the divisional secretary shall not be required. But in the old act, the divisional secretary has to give the approval for the mortgage. So that is there, Migara, that you are right in that way.
Also, madam, now with regard to the land development ordinance, there is a huge role to play for the government agent, meaning the divisional secretary, and also the land commissioner general, beginning
Yes.
from the process of land kachcheris and also up to the stage of succession rights. And
Yeah.
also in terms of section 104, where permits or grants can be cancelled. All
That's
those
right.
processes, a very wide discretionary role is played by the divisional secretary and the land commissioner general. Now,
Yes.
madam, if a party is aggrieved by a decision or a particular step taken by the divisional secretary or the land commissioner general,
Yes.
what are the remedies available for a aggrieved party?
That is, Vigara, you have to go by way of a writ to quash the decisions taken by these divisional secretary or the land commissioner general, sorry, the commissioner general of lands, to cancel. Now, in a permit, of course, permits can be cancelled by the divisional secretary. So that can be directly, if the parties feel that the divisional secretary has taken a wrong decision, erroneous decision, that is, maybe he has been biased against a party, wrongfully biased, then they can go for a writ. And on the other hand, a grant, of course, cannot be cancelled unless by the president. Only recommendations can be made by the Commissioner General of Lands with respect to the holding. That is also on a very limited basis. That is, the owner of a holding has deliberately given false information in order to obtain a grant, or the grant has been issued to a person other than the legitimate occupant. The Commissioner General of Lands shall issue a notice to the owner occupier in the prescribed form. And section 2 of 104A says they will be called for reasons shown unless sufficient cause to the contrary shown by the owner to the Commissioner General. What the Commissioner General can do is they can make recommendations to the President. But there is something like this. It's good that you took it up. Now, sometimes this is comes with respect to succession. Now, supposing in a grant, the permits, of course, is you can go for a writ. Under a grant, when a successor is nominated, the divisional secretary gives a form and a sort of a letter to the nominated successor. And he even registers the name of that successor in the folio relevant to that particular grant, where it says, it will normally say, the divisional secretary will normally say, Mull aithiya pavarima, and he will register the name of the nominated successor. Now, what happens? Sometimes these divisional secretaries, it has come up in a case, I can remember. What he did was the divisional secretary again cancelled that entry of the nominated successor. Now, the nominated successor is clearly given in the grant. His name was there. But what he did was, later, I don't know on what basis, he cancelled the nomination, the registration of the nomination. So, in my view, even that is also wrong. Because now when you, the nomination, when you give the nomination, it's just as if that nominated successor is the next holder of that grant. So the divisional secretary actually cannot decide to cancel the entry of the nominated successor. So even that has to be done by the president of the country. He must make recommendations to the president that why he is cancelling the nomination. So sometimes people misinterpret and say that the nominated successor is not getting a grant, but only the nomination he is getting. That I don't think that is the correct position, because when you are the nominated successor, you are nominated successor of that grant. The two cannot be detached from each other. The subject matter, the land, and the nomination, because they go together. So in that context, when you are the nominated successor, when the original grantor dies, you are like the next grantor. You are the holder of that grant. So the divisional secretary cannot decide to cancel the name registered as the nominated successor. Even in that instance, the parties agreed can go by way of a writ to quash the decision of the divisional secretary, because that is a statutory duty of the divisional secretary. So it's basically a writ remedy will lie for wrong decisions taken under section 104 and 106 of the Act.
We have a couple of questions from the audience. If I can just read it out, and if you need clarification, I can try to summarize it also. One question is, I would read that. What happens when a land alienated on a grant is transferred by the original grant holder to unrelated third party with the consent of the divisional secretary? Then, if such third party dies without nominating a successor, how does succession work? Is it under the general law or under the third schedule of the Land Development Ordinance?
Yeah, in that case, Megara, what happens is, at the beginning also I mentioned that section is section 19, subsection 6, 6B. You can dispose of such holding with the prior approval of the government agent. So what happens? So there's a big procedure for that. You have to get the prior approval letter. Letter has to be obtained with the approval of the divisional secretary. You have to give the draft transfer deed, the drafted transfer deed to the divisional secretary. For that also you have to get an approval. That approval is given a number also. And then after that, the notary can proceed to get the parties down all together and to sign the deed. So when that happens, the transfer is done by the original grantor to a third party. Then what happens is the ties with the Land Development Ordinance, which has with that land, is cut off. The land becomes like a normal transfer, although it is subject to the conditions specified in the grant. So that is the difference. So in such a scenario, the third party who has got the rights of that land subject to the conditions of that grant need not nominate any successor. There won't be a question of any succession thereafter, because once the divisional secretary approves these dispositions, then the ties with the Land Development Ordinance is severed. So it is like a normal transfer, but subject to the conditions of the grant specified therein. So a question of nomination by the third party does not arise. Supposing now the original holder with the prior approval of the divisional secretary writes to A, or say A. A has one son and one wife and son. So when A dies, it will devolve on the spouse and the child like normal under the general law. So half goes to the spouse, half goes to the children. So that is how people mistakenly think that the succession will follow, but that is not correct. Once approval is granted by the divisional secretary to dispose, that is the end of the bearing of the Land Development Ordinance. The ties are severed from that onwards.
There's also another question, madam. I think this was answered by you, but I will nevertheless read it out.
Right.
Owner dies appointing a successor. Will he or she not own the land until the spouse of the deceased dies? Or only if such spouse is a life interest holder, that such successor will not get to own the land. I think summarizing it, it means whether the successor would have to wait till the spouse dies as a life interest holder, or whether the rights of a successor are extinguished by a life interest holder. So I think you can answer that, madam.
Yeah, that is exactly section 73. If you read section 73, it gives a specific date of succession. That is, you have to wait. You have to wait until the spouse who has a life interest also dies. That is what the section says. So it specifically states There are three ways under section 73 under which a person can get succession and the date of succession. That is, from the date of the death of the permit holder or owner of the holding. 1. If such permit holder or owner dies without leaving behind his or her spouse. That is 1. Then 2. If such permit holder or owner died, leaving behind his or her spouse upon failure of such spouse to succeed. That is the second one. The third one is from the date of the death of such spouse as the case may be. So there are three instances under which section 73 elaborates how the nominated successor will get succession. So under the last limb I read out, the nominated successor will have to wait until the spouse has also died, enjoying the life interest granted by the Act. That is under section 73. It's very clear under section 73.
Madam, I think we have spent like good 1.5 hours discussing the various sections and developments on the Land Development Ordinance, and I think our audience would have very much enjoyed this webinar, which was very in-depth in terms of the sections and the developing case law. So on concluding remarks, Madam, is there anything else that you would like to add
I would
on
like
the developments of Land Development Ordinance?
Yes, I would like to also address the areas, only 2 areas on which the Act has not yet covered, and there are so many disputes regarding in courts, which either way is decided. One is that was I discussed earlier, when the nominated successor's name is registered in the folio as the nominated successor, can the divisional secretary regard it as a nomination, simply a nomination, without considering the person who has been nominated has got a grant, without considering the person who has got the nomination as a grant, and just cancel it? That area has not been covered. So one might argue and say the nominated successor is not a holder of that grant. He is just a nominated successor. But what does that mean? It means that either he does not have all the rights of a grant holder, or that he's just nominated for one. So that area has not been covered in the Act. So the divisional secretary can take undue advantages or against the wishes of the grantor who had nominated his or her son or daughter as the nominated successor. That area has not been covered. And the other one is, this is frequently happening, sometimes the person in occupation does not know another sibling had got the rights or the grant of the father or the mother long before. So when the sibling who has got the grant as the nominated successor or the firstborn child under the 3rd schedule, they will file an action in the district court and try to eject the sibling who is in possession. So by the time the sibling in possession finds out the other sibling who has filed the action has got a grant long before, it was very much about 10-20 years after the person in possession will get knowledge of such a grant. So will that bar a person from filing a writ application to cancel such a grant or a permit, mostly grants, will that amount of period that is also not covered by the Act. So that there has to be a remedy for the person who is in possession of the subject matter and who is unaware that another sibling had taken the grant of the father or the mother. So those two areas need to be covered by the Act. If not, those disputes can be resolved in a much summary way. So those are the matters I wanted to, in concluding remarks, in this session, Migara.
Right, madam. Thank you very much for sharing your valuable time with us. I think the audience also found this to be a very informative webinar. And I also thank the BSL for providing us with the opportunity of conducting this seminar on the all-important area of the Land Development Ordinance. And finally, I would like to thank the participants for sparing their time to share this knowledge on the Land Development Ordinance in this webinar. Thank you very much.
Thank you, Migara. And thank you, Isuri. Thank you.
Thank you, sir and madam. This brings us to the end of the 25th webinar of the series on Basics of Law titled Land Development Ordinance. I thank our esteemed panelist, Ms. Sudarshini Kure, Attorney at Law, and our moderator, Mr. Migara Das, Attorney at Law, the fruitful and educational discussion, and for dedicating your time to be here with us and sharing your insights. I thank the BSL Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. I also extend my thanks to all the participants who have joined in for this session today. Thank you, and I hope you all have a good night.